Property disputes are the most common challenges when it comes to probate. If you're dealing with disagreements among heirs, you're not alone. These situations can be stressful, emotional, and complicated, but there are ways to resolve them. Today, I'm going to walk you through what probate is and how it affects real estate, common family disputes over inherited property, and practical ways to resolve these disputes. Hi, I'm Denise Davis, the owner of North Carolina Probate Solutions and the owner of Fresh Start Realty, both located in North Carolina. Now, a disclaimer that I must put out is that I am not an attorney, and this video is for educational purposes only. If you have specific legal questions, I highly recommend that you consult with a qualified attorney. Now let's start with the basics. Now, probate is the legal process of settling a deceased person's estate. This includes paying off debt, distributing assets, and in some cases, handling any real estate that the deceased person owned. Now, in North Carolina, upon death, real estate is automatically passed down to the heirs, unless a will was created, leaving the real estate to someone else. However, before heirs can officially take title or ownership of the property, the probate process must be initiated. Now, most of the attorneys that I have spoken with recommend that title is not passed on to the heirs until after the notice to creditor period has completed. Now, just in case you don't know what the notice to creditor period is, I'll leave a link to a video where I explain exactly what it is. Now, the reason the attorneys recommend waiting until after the notice to creditor period is completed, and that was a mouthful, but the reason that they recommend waiting is because if creditors come forward and there's not enough money in the estate to pay the creditors off, there is a chance that the court may order that the house be pulled into probate and be sold. The money will be used to first pay the creditors off, and anything that's left will be distributed to the heirs. So today we're going to look at this as if no creditors came forth and there is more than one heir and the heirs do not agree with what should be done with the property. Now, some of the most common disagreements are disagreeing on whether they should keep the property or sell the property. Some family members want to keep the house as a cherished memory, while some family members may want to sell it in order to get the proceeds from the house. Another one is unequal contributions. One sibling may feel that they have invested more of their time and money in maintaining the property, leading to disagreements about what is fair. Another one is complicated ownership structure. When there are multiple heirs, everyone becomes a co-owner. Disputes often occur when one person is using the property or making decisions about the property and not consulting with the other co-owners. And probably one of the most biggest things that causes the disagreements is when there is no will or instructions left from the decedent on what to do with the property. Without a will, the state decides how the property will be divided, which may not align with everyone's expectations, causing more tension and disagreements. Now imagine 3 siblings inheriting a home. 2 wants to sell, 1 wants to live in it. Tension rises when they can't come to an agreement and they can't move forward. So when disputes arise, what can be done? Resolving disputes takes communication, compromise, and sometimes legal help. So I'm going to give you some approaches to help you resolve these disputes, starting from the least expensive to the most expensive. So you might want to take notes. 1, have open communication. Sit down with the family to discuss everyone's needs and goals. Be clear about financial concerns, sentimental attachments, and potential solutions that you think might be fair to everyone. 2, you can hire a mediator. A neutral third party can help facilitate discussions and find a middle ground that works for everyone. 3, consider selling the property. If everyone agrees to sell, it's important to work with a real estate professional who understands the probate process and who knows how to bring you the results that you're looking for from the sale of the property. Selling the home can simplify things, especially when the proceeds from the sale of the home can be divided equally amongst the heirs. 4 is to work with a probate attorney. An attorney can explain the legal aspects of probate, your rights as an heir, and help guide you towards a fair resolution. Now lastly, and you may want to take notes on this one, is a special proceedings called a petition to partition. A petition to partition is a legal action that allows one or more heirs to petition the court to force the sale of the property when they can't agree what to do with it. So here's how it works. When multiple people own a property, whether they inherited it, purchased it together, or acquired it through some other means, they all have equal rights to the property unless stated otherwise. Now, if the co-owners can't agree on whether to sell it, keep it, or divide it, any one of them can file a petition to partition, asking the court to force the sale of the property. Now, if the petition to partition is granted, the court will order the property to be sold and the proceeds are evenly divided amongst the co-owners. Now, there are some pros and cons to the petition to partition. The pros: this resolves the dispute when the co-owners can't agree, and it ensures that everyone receives their fair share of the property value. Now, the cons: it can be costly, involving legal fees and court costs, and it can strain the relationship even further amongst the heirs. Now, keep in mind, if one of the heirs wants to sell the property so that they can get what is rightfully due to them, the other heirs have the right to buy that heir out. So if the property value is $300,000 and two of the heirs wants to keep the property and one wants to sell it, the two heirs that wants to keep the property can buy the other heir out by paying him $100,000 for his ownership part of the property. He gets his money, and the two other heirs gets his share of the property, and they get to keep the house. Now, if you have gone through this, tell me in the comments section below, how did you and your family handle it, and did it change the relationship? I'm curious to know. Now, I hope this video has helped you to gain an understanding of the different ways to handle property disputes. Now, if you have property to sell in North Carolina due to probate, property that you inherited and need to sell, or maybe you just own property in North Carolina that you want to sell, feel free to reach out to me so we can discuss the best options to get your house sold. Whether it's a fast cash offer or listing it on the market for top dollar, we have a solution for every property. You'll find my contact information below. So please don't forget to like this video and subscribe to my channel. And until the next video, be blessed.